All right, guys. So we are all done with day 2 of the Wealthy Trustee workshop. So we have just officially completed our private family trust. So I know I went through a lot of information, but we are building upon what we set forth yesterday. So yesterday we went ahead and established our business trust, and now today is us actually building upon that. Okay, so what I want to do is I want to open up the floor for Q&A so that I'm able to answer any and all questions that you might have. The first question that I do want to start with was Miss Sheila. She had asked a question in relation to Miss Sheila, can you come off mute? Do you remember what your question is? It was in relation to putting it all together as far
Right,
as
right.
far
What
as, go ahead.
what do we have to gather together in order to go to the clerk's office to file everything?
Okay. So it's there's multiple things involved in with this question. So the first thing is with your trust, right? Once your trust is notarized, it's already legally binding. It's legalized and you can start operating it. Your trust documents are private and they don't need to be registered anywhere, meaning they don't need to be registered with the county, they don't need to be registered with the state, okay? Now, if you are placing assets into that trust,
Right,
then you have to, it's a two-step process. The first step is the one that I just showed you guys, where you have to list it on the Schedule B. Okay, so let me just go really briefly. Let me go back um to that section. Okay, so here in Schedule B is where you've listed the assets. Okay, so that's step one, is that you've listed the asset that you are referring to. You've listed it on the Schedule B of your trust. Step two is that your trust needs to be notarized in order for it to be legal, because now that it's legal, it can own the assets. If your trust is not notarized, it can't own the asset, okay? Now that your trust is notarized, then you're able to take the next step. So the next step is for you to, so let's just talk about your primary residence. So for the next step for your primary residence is you have a deed to that property. So you have to fill out a new deed. So the templates that we provide you with are quitclaim deeds. So on Friday, I'm going to go step by step and show you guys how to fill out the quitclaim deed. So now that you have filled out the quitclaim deed, it needs to be notarized, okay? And so you will be able to sign over in front of a notary in your particular county and state where the property is located, okay? So you're going to sign in front of a notary and you're going to be signing over that particular property to the trust. You're going to be gifting it to the trust, right? And so once that notary signs and seals, now this is a legal instrument, right? Which is your new deed, which is your quitclaim deed that you can now go ahead and record with the county. So now you're going to, and I'll show you this because I just went through this with somebody. So hold on. So now what you're gonna do is you're going to submit it with the county recorder's office. So I just I just looked this up yesterday. So this is the recorder's office. That is where you record deeds, okay? So you're gonna look up, you're just gonna put your county name, and you're going to put recorder's office. That's how you're gonna look up where to record your deed. So now you see it says the address, the phone number, the hours of operation. So go ahead and call them. to see if there's any additional information that you need to provide. Some counties won't ask you for anything but the deed. Some counties will ask you for an owner transfer form. So you have to just do a little bit of research to find out what your county requires additional to the deed, okay? And for example, if they require an ownership transfer form, that is to prevent deed fraud. Okay, so that is for your benefit and for them to verify that you truly are the owner of that property and that you are the one that's transferring that particular property into the trust. Okay, so now that you have this official deed, you're going to go down to the county, you're going to submit it. They are going to record it and they're going to take a copy and upload it to the public records. And they're going to provide you with your original copy for your new deed. So that's how you're going to register with the county that the trust is the new owner. You do not have to provide the county with your trust. 9 times out of 10, they won't ask. You have some counties that will ask, and you have to let them know that you have to decline basically, and let them know that you're not going to provide them with your trust documents and that they're violating your privacy rights. Majority of the counties, they are in alignment with the fact that your trust is private and that they won't ask you for it. The most that you would have to do is provide them with your certificate of trust, which is that summary to show them, yes, this is a legalized entity that I am transferring this property into. Okay, so those are the steps that you have to take, and we're going to go step by step even further on Friday when we focus on quitclaim deeds.
Okay, one other question that goes along with that. I have a piece of property and I'm not in that county at the moment, but I'm having everything notarized in the county that I am in right now, speaking with you. But my property is in a different county. Question, do I have to have all of my documentation notarized in the county of the property that I'm doing the quick claim deed for? Or does
It
it matter?
it depends on the county.
Ah,
It
okay. So I have
depends.
to call them and see what
Yes,
okay.
yes,
Mm,
yeah, you do.
okay.
So I always tell people, if you're able to, get it notarized in the county
Mm,
where the property is located. But
okay.
you have individuals that are owners that don't live in the same city and state. So they're not able to do that. So it just depends on the county. I had one of our trustees that she got it notarized in the next county over, and they told her no. And so she
Oh,
had to get it re-notarized. So
okay.
so it depends on the county.
Thank you so much.
You're welcome, Ms. Sheila. Thank you for asking that good question. All right, so we are going to continue with Q&A. So next we have Miss Angelique.
It's me again. Can you
Yes,
hear me?
yes,
Okay.
ma'am.
So this time, piggybacking off the original question, how do we become volunteers? How do we get on the volunteer list? I think I had emailed you and told you that I'm gonna get my notary like certificate again. So I used to have it before, so I thought it might be easy for me to try to get that again. But as far as the other designations, how do we become? Do we got to be here for so long? What's the requirements for that?
That's a good question. So we send out I think we do it every 2 weeks. But I will have the team send it out today. And we send out a request form. And in the form is where you are going to go ahead and volunteer. So you let us know inside of the form what capacity you want to serve in. So if you want to do notary, if you want to do grantor or board member, then you'll let us know. So it's just a quick little like checking the box thing. And if you want to do multiple, then you'll just list and let us know, and then we update the volunteer list, and then we send it out every 2 weeks to the community so that people know who they can reach out to.
So for notary, is it online notary like we had? I had to do that with the property, with the virtual property postal part. It was an online notary, so he did Zoom with me and had me upload my ID. Is that how we do it with you guys, or is it physical?
So every single state notary is different. So some states they let you do electronic notaries and some don't. So it depends on your respective state. So if you are only able to do you're only able if you're only able to do within your state, then that is the capacity that you serve in. So you would just let them know, hey, what state are you in? Are you in Florida?
Ohio.
Ohio. So then you'll let them know you're an Ohio notary.
Okay.
Yeah.
Okay, that's good. And other question. So today you said that the successor can be a beneficiary, but yesterday did you say it cannot for the business trust? The beneficiary can't be anything but a beneficiary in the business trust. But
So that's a really good question. So the beneficiary cannot have any power or control. So the beneficiary can't be the grantor, can't be a trustee, can't be a board member, right? But a trustee can be a beneficiary, right? But the trustee, if the trustee is going to list themselves as a beneficiary, they cannot be the sole beneficiary. There has to be other beneficiaries. Now, if if you want to, because the successor has no power, the successor doesn't have any power and control right now. They they will have power and control once they become the trustee, right? So the beneficiary can be listed as a successor, but they're just pretty much a placeholder until that happens. Now, let's just say you resign, you step down. Now that beneficiary can move, since they're the successor, they can now move up and have power and be the trustee. They can still be listed as the beneficiary as long as there's other beneficiaries. So at no point in time can that successor that just became a trustee be the sole beneficiary. So it's just a little bit technical, but it can happen.
okay, I can understand that. I can understand that. Okay. And my last question is dumb, but I don't remember where you said yesterday to find the video that's uploaded an hour later because I was in a meeting in the beginning of this and I missed some stuff in the beginning. So
Okay,
where is it on your, where do we go to find it?
do you have your login credentials?
For
The portal.
I'm getting the portal. I don't know. I'm getting it from my email. So I click in from my email. I just click on the link from the email and that's how I get here.
Mm.
So I don't
So
know.
So you missing a whole nother half of it, okay? So you have login credentials. It might be in spam. I talked to a couple people, some of their stuff went to spam. Not sure if yours went to spam, but just do a search in your inbox for the number
Okay.
7, ways to wealth. And in one of those emails, when you first enrolled, is your welcome email with your login credentials. So it's your
Hmm.
email and then a password. So you have to click on that link and it lets you into the portal. In the portal, you're gonna see two courses. One course is the program with the 43 video modules. The other one is the workshop recordings. So you have to click on the one that says workshop recordings, and then you scroll
Okay.
all the way to the bottom.
Okay, so I am in the portal because I have access to the videos, so I must be there somehow. Wherever that is, that's where I go to find the videos, right?
Yeah,
I have that.
you logged in, you had clicked the link and it showed you the course.
Yeah, I've been watching the courses, yeah.
Do you have two of them?
Yes.
Okay.
I do.
Okay. So
I must be got in it, and it just must be it must be saved or something because I don't put in a password or anything
yeah,
like that. Just
it automatically, yeah. So once you click that link, it just auto enrolls you into, so it automatically does it for you.
okay.
Unless you log out, then you're gonna be forced to put in your username and password.
Okay. All right. That's all I have. Thank you.
You're welcome, Angelique. Thank you. All right, next
Mhm.
we have Miss Kamala.
Hi. How are you?
I'm good. How are you doing today?
Okay. Just piggybacking off of the last caller. Um, yeah, I didn't see anywhere where you log in and you put in a username and password for you to get the videos from yesterday. There wasn't anywhere. All I get is on my regular cell phone, it has the Zoom meeting address, and I just click on it, and I'm automatically taken to you where you're speaking live. As for, they have not sent anything where you could log in so you could rewatch the videos, because I do need to rewatch the videos again from yesterday, because yesterday was the first day, so I didn't get to, put in all the information that I needed to put in the first session that we had yesterday. So um, my first question. The second one is, you're saying that the grantor, and I know I'm repeating what you say, the grantor cannot be any family member. It has to be someone else.
So no, the grantor can be a family member. So it's best,
Oh, okay.
it's best. So best practice is for you to choose someone who's not related. If you can't find someone who's not related, then you can choose someone who is related.
Okay, all right, thank you. And the next question is, you were talking about a quick claim.
Mhm.
Like my house, my ex-husband is still on the house, the house claim that's coming in. So, I mean, when I get a divorce and everything, the lawyers help me to do a quick claim and everything, so the house is in my name. But the bank is still sending payment in both of us' name. So can I still put the house into the trust even though both of us' name is on there, but we're not together anymore?
Okay, so it's okay if both your name is on the mortgage, that's fine. The way that you transfer the property is through the current deed. So you
A
are
quick
the
claim.
owner, correct. You already recorded it with the county, right?
Yes, and have a quick claim deed when the house that came over to me after divorce.
So you are the only person who's on the deed, correct?
On the quick claim deed, not on the statement from the bank.
Okay, so the mortgage is irrelevant, right? The mortgage doesn't represent who the owner is, the deed does.
Okay. All
So
right.
you're the only person who's on the deed, so you are the only person who's required to now claim it from your personal name into the name of the trust.
Under the name of the trust. Okay. And thank you. Thank you for that. The next question is, when you're going to the bank with all of this, do you need to bring all your paperwork from the trust, or do you just need to bring a portion of it to open that bank account?
Yeah, so I would tell you okay, you only need two things, your certificate of trust and your EIN number.
Your certificate of trust and yeah, and number. Okay. Okay, so before we do all of this, we have to apply for EIN number before
Yeah.
we go
Yeah.
any
So
further.
we're
Okay.
we're gonna begin that process tomorrow.
Okay, and my next question is, thank you, is that list where other people where you could work with and that, because I have so many questions, but other people waiting and it's unfair to them. So I need that list. So after when you're finished with us, I could still be communicating with people within the community because I have so many questions and this is all new for me. Okay?
Yes,
So I
absolutely.
need that list.
Are you gonna get into the to the Facebook group and the Telegram chat?
Yeah, I remember you sent that something yesterday to join the Facebook group. I definitely will. I have not done that yet, but I definitely will.
Okay, perfect. Okay. And then I'm gonna quickly share my screen here so I can show you an example. So when you log in, right? When you log in, you should see these two things. One says workshop training recordings, the other one says wealthy trustee program.
Okay.
So you need to choose the one that says workshop training recordings. So you click on it, and then once you get in there, it shows you all of the workshops. So it starts from 2023. You have to scroll all the way down to the bottom. And then it
Okay.
shows you workshop December 2nd to the 6th. So you click on it, and then it'll show you day one. So you click on day one, and then here's the video.
Okay. And my last question is, tomorrow I have a job interview. I will not be able to attend. So I just still could just go into that video and watch tomorrow's session.
Absolutely. Yep.
Okay. All right. Thank you. That is
You're
my
welcome.
last question.
Thank you so much. Thank you
Okay.
so much for being here. All right, next we're gonna go to
You're
Miss
welcome.
Joyce. How are you, Miss Joyce?
I am doing just fine. How are you?
Oh, I'm doing splendid, wonderful. I'm having my coconut water here, feeling wonderful.
Oh, wow, we're drinking the same thing.
Yay! I knew
Okay,
it.
so I am the spouse of Mark Jefferson, and I'm forced to be on these trainings as well because I'm more tech savvy than he is.
Okay.
But my question, the certificate of trust, where exactly? Because as I was looking through the information of trust, it's the notary pages, or is another page that's going to come up that says certificate of trust, and we just fill it out.
Yeah, so it's past it's one of the notary pages. So within your packet, you have about 5 pages that need to be notarized. So it's one of them. So it's towards the very end of the trust document. So it's probably like the second or third to last page. So if you see Schedule D, it's the page after Schedule D. So
Gotcha.
yeah, it just depends on which
So that certificate of trust and the EIN number are the only two things that need to go to the bank to
that's
open an account.
yep, that's correct. Yep. So we're gonna apply for the EINs. I'll show you that process Wednesday, Thursday, and Friday.
All right. Next question. Within the document, you have some words all caps. Does the caps make a difference? Because see, I'm technical. If you have all caps, I feel like you're supposed to have all caps. If you're doing upper and lower case, I'm thinking it's okay. Or
Yes.
how?
So so it depends on how you want to do it. The capitalization really doesn't make a difference. Some people feel more comfortable using all caps when they're referring to their name or when they're referring to the state.
Okay.
So yeah.
So that was really my question because I was typing, then I realized, oh, she had all caps here. So therefore, she must want us to put all caps here. So it really doesn't matter.
Yeah, correct.
Okay. Well, thank you. Those are my two questions.
You're welcome, Ms. Jefferson. Thank you for being
All right.
here.
No worries. Thanks.
Uh, Next we have Monet.
Hello?
Hi, how are you?
I'm good. How are you?
Wonderful.
Um, Question about grantor. You put throughout the document John Doe. Is that what we're really supposed to put, or are we supposed to put the person's name as grantor?
Oh, yeah, that John Doe is my grantor. You can't use him.
Okay.
I know him. Um, so you need to put your person. Whoever you choose as your grantor, you put their person.
You put their name.
Yeah,
Okay.
you put their first and last name, their legal name.
Okay. So, with the grantor, okay, let's just say I'm the grantor and I have assets that I want to put into the trust. Am I able to put into a trust, or does someone else have to do it instead of me?
That's a really good question. So anyone can put assets into the trust. So if you have a grandmother, if you have a grandfather, if you have a sibling, if you have a neighbor, if you have a best friend, they can put assets into the trust. So anyone can do it. The trustee can do it. The grantor can do it. So it's all discretionary, but ultimately the trustee is the one who has to accept all of these assets. So if you have assets that you want to place in the trust, you can do it yourself.
Okay, and then once I do that, then I'm done. I can't do anything else to the trust. I can't amend it or anything once I fund it.
No, that
Okay.
is, no, that's not true. So
No.
the grantor is the one who cannot amend the trust, cannot change the trust, cannot terminate the trust, cannot remove the trustees or beneficiaries. The grantor has no power and no control. You as the trustee, you can make amendments. So we went through that when we had talked about the trustee powers. I'm gonna pull it up just so that I can
No,
read.
you no no no. You're right. I said that, but in this case, I am the grantor, not the trustee. So
Oh,
I'm not able to do anything anymore as the
correct,
grantor. Okay.
correct. Oh, I didn't know you was the grantor. Okay. Yes.
Yeah.
Okay. Is this your trust? Do you want to be the grantor?
Um, I'm playing devil's advocate. It's a parent that wants to do it for their and wants their child to be the trustee, but it's the parent's assets that they want that goes into the trust. So it's
Oh,
the parent that would be the grantor or not.
no. Wait, are they the trustee and their child is the beneficiary and you're the
No, this is an older parent who wants one of their adult children to be the trustee. They only trust that child, and the other two are going to be the beneficiaries.
and they're the grantor?
Yes.
Oh yeah, that's fine. But I thought you said you was the grantor.
No, I was just playing devil's advocate.
Oh, okay. Yeah, that's fine.
Okay.
Yeah, that's perfect.
Okay. And just I think you said it, but I just want to make sure I understood. Um, if that third child is the trustee, they can also be the beneficiary as long as there are other trustees. They can't be the sole trustee, correct?
Beneficiary. So as long as they're not the sole beneficiary.
Oh, okay. So they could be the trustee and the beneficiary if there's other beneficiaries.
Correct.
Okay. Isn't that like a conflict of interest? Like how they will be handling the assets as well as benefiting from it?
Yeah, it's okay. So it's
Okay.
gonna be one of their forms of compensation, but that's why they can't be the sole. It's a conflict of interest if they're the sole.
The sole beneficiary. Okay. Thank you.
You're welcome. Thank you, Monet. All right, next we have Crystal. Hey, Crystal.
Great day. How are you?
Wonderful, splendid. I'm drinking matcha green tea latte and coconut water at the same time.
I just threw away my coconut water bottle.
Yes, it's phenomenal. Yay.
All right. So I want to thank Miss Kamala, is that her name, for
Yeah.
bringing that situation up, because I'm kind of like, you believe it or not, I'm going through a situation with my ex-husband. We've been divorced for 8 years. We don't have any children together, and he reopened our divorce case.
Oh man.
That's those 8 years. So thank you for bringing that up, because I mean, it's almost the exact situation. I actually have a quitclaim deed that a substitute trustee ordered by the court took his name off of our joint property. So I'm gonna have to put that into a trust now because he doesn't act like he doesn't know that's what happened. So I thank Ms. Kamala for bringing that up.
You're welcome.
The situation that the Monet just brought up was very interesting because I am by myself, and you saying that I can't be the trustee and the beneficiary unless if I'm by myself. So I do have a brother and I have my parents. So I was gonna make them beneficiaries. A brother, a sister-in-law. I have my sister and brother-in-law and nieces. I was gonna make my brother the substitute trustee, but he will also be the beneficiary. And I was gonna ask if he's not available, then I wanted to bring in, I have a god sister and brother that have been helping me. How do I make them family members? That's my question.
Okay, so your beneficiaries don't have to be, they don't have to be.
No, I mean trustee. I wanted one of my my god brother to be a substitute trustee for me.
Okay, so you want him to be the successor?
I want him to, okay, so
Or you want him to be acting as a trustee with you right now, like y'all do it
but he
together?
would be a substitute and my brother would be a substitute. That's what I was trying to do.
Okay, and that's if anything happens to you?
Correct. Like say for instance, I was needing surgery or something. I need somebody to take over for me, for my parents, just in case something happens to me.
Yeah, so that means that they're going to be the successor trustees. So you can list both of them as successors. And then if anything happens to you, if you become incapacitated, if you decide to resign, if you expire, then they will be able to take over for you. So you're gonna appoint them as your successor.
So I would have to take those clauses out that was specifically saying that a family member needs to be a trustee. Is what would I do?
No, a family member doesn't need to be a trustee. No, 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 no. So you can have, there's provisions in there that says you can have an independent, an adverse independent individual be a trustee. So they don't have to be related to you. You can even hire someone like, off of the street to be your trustee
Okay,
if
all
that's
right.
what you want.
Okay, that was my first question. My second question was, I was going to ask, is there a particular state that you recommend? But I heard you said it doesn't matter, but then I'm looking at the commonwealthtrust.com and they're mentioning 7 states that would be the best for putting your trust in. Is that doable? Or I mean, because I mean, I'm in Maryland, my parents are in North Carolina. I was going to do a trust for my parents and then do a trust for myself, but I like the way Delaware is looking, to put Delaware down. So would I get a Delaware address? Or
So when you're doing your research, when they talk about specific types of trust, they're referring to statutory trust. And the reason being is because, for example, the Delaware state statutes are embedded in that type of trust. And so if that state has favorable laws for trust, then you want to gear towards that state. So we don't have a statutory trust, we have a non-statutory trust.
okay.
So our trusts operate under the common law jurisdiction, and so the state statutes don't necessarily apply because we don't have them in there. So you can choose whichever state you want. Now, if you want to move forward and choose Delaware, you can. So when you are wanting to choose Delaware, just make sure that you do have a Delaware address because you're going to be choosing that state as the domicile of that trust. So meaning that your trust is a living entity and needs a residency, you're choosing Delaware as a residency and you're providing a Delaware address. You can change that at any point in time as the trustee. You can make those amendments, but if you're going to initially set it up that way, then just have the address aligned with the domicile or residency.
Okay. The third thing, thank you so much.
You're
The third thing was under charities. That was kind of interesting. How would you do like tithes and offerings?
Oh, we're gonna talk about that tomorrow.
Okay.
Yeah, tomorrow we're gonna go through the tithes, the donations. I'll show you what the receipts look like. And we're talking everything nonprofit tomorrow.
Okay. I just want to make sure I got everything. Trust certificate. Okay, I think that's it. Thank you so very much. I'm so grateful.
You are so welcome. Thank you, Crystal. All right, next we have Shari.
Hi,
How
thank
are you?
you. I'm good, thank you.
You're so
How are
welcome.
you?
I'm wonderful. I'm splendid. Thank you for asking.
Great. I'm a little nervous. I have so many questions, but I'm going to ask only a few in the interest of time and other people. The first question I have to ask is when you make changes to the parts of the trust, do you, and the parts of the trust affect those parts that had to have been notarized? Do you get do you re-notarize it once you make the change? Does
So
that make sense?
yes, it does.
Okay.
So there's two things that you're going to do. One, you're going to have a board meeting, and I'll show you how to do that on Thursday, where
Okay.
you're going to express the changes that you're going to make with the trust. The second thing is that you'll do an amendment to that article and that section where you are amending. So you'll do amendment 1, and then you'll list the area that you're amending and the actual amendment, the change that you're making, the update. And that update, that first amendment, amendment 1, needs to be notarized.
Okay. So the amendment needs to be in there. Okay. And that's the same because I had a similar question yesterday for the business. You have to do the same thing?
Yeah, for any trust.
Okay. Okay. And then the second question that I had, thank you.
You're welcome.
The second question I had asked, do you have to set up, well, this is kind of complicated. Do you have to set up a separate bank account for each one of the beneficiaries in the family trust?
No, you're not responsible for setting up bank accounts for the beneficiaries. You're
Okay.
only responsible for setting up and managing the bank accounts for the actual trust. If you're going to be giving distributions, you're going to request banking information from the beneficiaries, and then you'll issue distributions to their personal bank accounts.
Okay. All right. That makes sense. Excuse me. The third question that I had, and I think that's the final one for today, is how do you file taxes on the trust?
So you have to file a form. So the way that we're structured out of our 3 trusts to qualify in order to or are required to file taxes. You file a 1041. So inside of the course, we have a whole section on taxes.
Okay.
So you as an individual, you file a 1040, a trust files a 1041. So I'll show you what that form looks like. And all you have to do is, I personally don't recommend that people fill out their 1041 personally. I think that they should go to a CPA. So we are partnered with different organizations that will help you, with that process.
So,
Uh-huh.
second part of that, would the business and the family trust file the 1041?
Oh,
Or
yes, I'm sorry, I forgot to mention that. Yes. So the business trust and the family trust are for-profit entities and they file the 1041. And the nonprofit, it qualifies. So as long as, and we'll talk about this tomorrow, but as long as you have income under $5,000 for the nonprofit, it doesn't have to file. So anything that's coming into the nonprofit, it has to be labeled as a tithe or a donation. Anything that's labeled as income, as long as it's under 5,000, you don't have to do the 1041. If it's over 5,000, then you do. That's for the nonprofit. But business trust and family trust, it's automatic. You have to file.
okay.
So this is what the form looks like.
Mm-hmm.
And this is how you are going to fill out. And once again, get your tax preparer, get your CPA in order to do it. If you guys need help finding someone, just reach out. We'll be able to point you in the right direction. We're partnered with 2 CPA companies that are familiar with filing taxes for trusts and these forms here, which are the 1041s. So you're just gonna put all the entities, information, the name and the title of the fiduciary, which is you, and then these are the various different types of income. So you got interest, you got dividends, you got business income, capital gains, any rents, royalties, things like that, ordinary income, and then you have your deductions. So taxes, fiduciary fees, which are like compensation for all of the fiduciaries. That's your real estate, that's your financial advisors, your attorneys, stuff like that. Any charitable deductions. So if you are donating to your ministry trust, is 100% deductible. Your other fiduciary, so this fiduciary is for you as a trustee, and then you have your other counsel, which is attorneys, accountants, tax preparers, stuff like that. Any net operating loss, so this is your assets, um, and estate tax deductions, anything like that. So those are your actual deductions, and then you'll, add up all the lines, sign, the preparer will, go ahead and put their information. So this is available for you inside the program. We have that as a resource and we'll like break it down. So, but like I said, I don't recommend you do it yourself.
I wouldn't. One last quick question. For the, do you have to have a separate bank account for the business trust and the family trust?
Yeah, you do not want to commingle funds. So
Okay.
you want to use one bank account for all 3 of your trusts or 2 of your trusts. Every trust is a separate entity. So just
Okay.
look at it as a separate business. It has its own name. It has its own EIN, which you want to look at it kind of like a social security. It
Okay.
needs its own thing, which is a bank account.
All right. Good. Thank you very much.
You're welcome. Thank you so much.
Bye-bye.
All right, next we have Eric.
Christina,
Hey,
how are you doing?
I'm wonderful. I'm just enjoying my coconut water.
Awesome, awesome. So, two questions. So, the first, is it typical for people to separate, like, do a ministry trust in one state and the business in another state, or do people just kind of do them all in one state for the most part?
Most part, they do them all in one state.
Okay, okay, all right. And then as far as with the iPostal, because I know, like, in my business, I use a virtual office, but I know that with the business incorporated trust, should we use like a alliance, and then for the other one, will you do like iPostal for like funding purposes, or it doesn't matter?
You just so you just want to use one company, and you can get all of your, virtual address needs off of one company. So whatever company you already have an established relationship with, you can. Some are better than others, and that's why I recommend iPostal, because some of those other virtual companies, their addresses get flagged or they get rejected, things like that.
Okay, awesome, awesome. Thank you. I appreciate it. And then now which one of these trusts are eligible for like grants, if possible?
So it depends on the type of grant, right? Because if you're talking about nonprofit grants, then it's the ministry trust, or if you're talking about standard business grants, then it's the business trust. So it depends on the type of grant you're talking about.
And do you see people typically get grants for the business trust?
Yeah, if they apply for it.
Okay, I appreciate you. Thank you so much. Have a good one.
You too. Thank you, Eric. All right, next we have Michelle.
Hello?
Hi, Michelle.
Hi, how are you?
Good, wonderful. How are you?
I'm good. I just have a few questions. Can the family trust serve as the grantor for the business trust and the ministry trust?
So, no, because the family trust is going to be the beneficiary of the trust and the ministry trust.
Ah, okay. So my spouse and I will be serving as trustee and co-trustee of the family trust. Can we also both be beneficiaries, or would that require one of us to not be a trustee?
So as long as you have someone else or something else serving as a beneficiary, then you'll be fine.
Okay, and another question. My mom will be serving as the grantor for my family trust. Can the grantor be beneficiary if there are other people as well?
No, the grant does not benefit from the trust at all.
Okay, and one more. In Article 15, Section 12, can we change the details in there to, like, if for any reason, like I were to expire, can the biological mother, if I can't be the trustee, can the trust withhold his beneficiary payments or anything he's getting and reinvest until a certain age?
Absolutely, yeah, you can customize it and put, whatever is applicable to your family. So you can
Okay,
put that in there.
all right, that's it. Thank you.
You're welcome, Michelle. Thank you. All right, next we have Aset. Hey, Aset, how are you?
Hey there.
Hey, how are you?
Today wasn't so painful, so I don't
Oh,
know why, but it was easier to absorb and stay pretty focused. I needed 1,000 cups of coffee yesterday. But okay, so you're welcome.
you look warm.
Oh yeah, I'm cozy. So
Where are you at?
in South Carolina, so it's like super cold over here.
Yeah,
Wow.
I'm in Georgia. It's a little cold over here too.
Yeah, we've been getting frost all over the place, and my whole garden just died in 2 days. It's
Oh,
gone.
that's tough.
Very
My
sucks.
goodness.
Yeah.
Mm.
So
Mhm.
I thank you once again for your assistance
You're
because
welcome.
I'm forever grateful. So I have you read the notes. It says after the notary, will you like say for instance you have your grantor in another state and that grantor sends everything back. Does it have to be in its original form, or can the seal be uploaded and emailed?
So after the grantor has notarized it, you're saying if they can just upload and email it to you.
Is
So
it
yeah, you want it to be original. So you want to have both signatures in wet ink for the original document. Once it's fully executed, then you want to upload it so you can have an electronic version of it.
okay? I upload it, but I have the original. But I can upload it as long as I have the original and the it's not been sent as a copy.
Correct.
Okay. If you are not alive, how can or who can speak in a time of the process, which is referring to Section 5, Article 3. So I think it was more of if I passed away, can you go back to that section? It's under
Yeah. Okay. What is it?
Article 5.
Article
I'm
5.
sorry, Section 5, Article 3. I'm not sure if I put a typo for protector.
I have, oh wait, hold on one second. Article 3.
Article 3, Section 5.
Okay, one second.
Something like if you're not alive,
Um,
speak for that and I know the successor, but what if
Article 3, General Trust Administration, is that what you're talking about?
yes, the board of trustee may purchase or sell. So if that person, if the beneficiaries,
Are you talking about this section 5 right
okay,
here?
yeah, funds occurring, yes.
Okay, so the funds that are accruing inside of the treasury of the trust are going to constitute as operating funds of the trust. So if you have money that's coming inside of the trust, then that money that's coming inside of the trust, you're going to use it to operate the estate. The board may sell any trust assets for the purpose of holding the funds, for adding to the funds. So if enough funds is not coming in, then you as a trustee can decide to liquidate an asset in order for you to have that liquidity that's going to add to those operating funds in order to sustain the trust estate. The board shall, as it deems proper and necessary, provide operating funds through any type of borrowing, either secured or unsecured. So remember, we said that the trustee can lend to the trust and can also borrow from the trust. So those operating funds can also be used for lending purposes as well.
Okay, I don't think that's the section, but I have to go back and look at our at the recap because it was in regards to who can speak for it. So it's another one of those moments on my behalf. So it says, can you be the lien holder? Can the trust be a lien holder, first lien holder on your home? Can that be utilized as a tool?
Yeah, absolutely. You can put a lien on your property.
And that's by just, is there like a maximum amount that you'd have?
So it depends on if you have a lien on your property already,
Right,
because
if you
you
don't.
already have, right. If you don't, then yes, they can have first position. If you do, then your trust will have second position.
Right. So what's the minimum of, like, if you have to, they say you have to create a loan, does it matter the amounts?
You want to put it for the value of the asset.
Gotcha. Okay.
Mhm.
So is the board of trustee the same as the first trustee regarding
No.
protectors?
So the Board of Trustees is a group of individuals that we call the governing body, and they pretty much operate the trust. Now, first trustee is the first board member, and then the first trustee is going to appoint the other board members. So right now, you don't have a board, but you are the trustee of your trust. So now you create the board and you're the first member and you have to fill those other two vacant positions. So you have to appoint two other people. So you can appoint a general manager or a secretary or a treasurer, whoever you want. You have to appoint those other two board members.
And the trustee, when you do appoint those, you can never be on the board as the first trustee.
You are
You
on the board as the first trustee. You're the
Okay,
first
gotcha.
member of the board.
Okay, all right.
Every single trustee is a board member.
Okay, gotcha. Okay, and can you name a ministry of foundation?
So no, it gets confusing. You don't want to use the word foundation. Foundations are ran very separate from ministries or faith-based organizations or charitable trust.
Okay, okay. Do you teach those? Do you teach that?
No, I have a partner that teaches about foundations.
I'd love to learn more about it. Um, it says if one cashed in, okay, I answered that one. You answered it for me. Can a bank directly contact the grantor for banking purposes or security measures? Meaning that if the grantor wants to, if you want to continue to make the grantor comfortable and the bank is asking for the grantor's information, is that something that they would be able to do?
Yeah, that happens all the time. So that happens all the time, and whatever information that they need from the grantor. So the grantor can provide it directly to the institution. Yes.
Okay, that's great. That's great.
Mhm.
Can the certificates, oh, okay. Can the certificate of trust be the home address? Because I know you were saying for the business yesterday, it shouldn't be. But since this is a family trust, does that matter?
So, I personally would tell you that you don't want the trust to have the same address as you.
Okay,
So if you've already been using your personal residence as your primary address, then don't use it for the trust,
okay,
even though the trust is the owner of the asset.
okay. And so you only notarize the certificate of trust. That's it.
No, there's a bunch of there's a bunch of forms that need to be notarized.
So
So
what we're creating right now, that thick packet or whatever, the 60 pages or whatever the case is, that's supposed to be brought with to the notary as well, along with the certificate of trust.
yeah, the certificate of trust is within it. Yes, it's like the last 2 to 3 pages.
Okay, cool. All right. And then a trustee to a trustee can a beneficiary. Okay, so with this beneficiary thing, in the trustee also being a beneficiary, I hear that you're saying that they have to have more than one beneficiary, not just one. Is that only pertaining to this trust or the business trust as well?
The business trust as well. It's pertaining to irrevocable trust.
Okay, I got it. Okay. And last one. The assets listen. Okay, I found that. Okay, cool. Thank you very kindly. Appreciate it.
You're welcome, Asad. Thank you.
Welcome. Take care.
All right, next we have Chance.
Hey, Christina, good afternoon. Got a few questions for you. Appreciate all that you're doing.
Thank you, thank you, thank you. How are
Good,
you?
good. I'm doing all right.
All right.
These may be overlapped. Question.
Yeah.
So, with the family trust, and I guess with the business one as well, if both husband and wife are like joint owners to the assets, house, etc., right?
Mhm.
Now, these got to be put in the trust, but how is that going to work for the other partner being a beneficiary, or do we need separate trust?
So the trustees don't have to be beneficiaries. So both of you guys can just list yourself as trustee, and then you guys don't like both trustees don't list themselves as beneficiaries. Another thing is that both of you guys can be listed as beneficiaries. You just have to have it has to be multiple beneficiaries, not just only you two.
Well, for sure, yeah, because we have like our kids and so forth in there as
Yeah,
well.
yeah. So generally, trustees don't list themselves as beneficiaries. So
Okay,
generally, they list their children.
alrighty. On this specific one, though, I mean, I want my wife and I are going to be both like I'll be the main trustee. She's a co-trustee, and Texas also is like community state. So I obviously want her to be a beneficiary.
Hmm.
So that's cool on there.
Yeah, absolutely.
Okay, now I think this was already answered. So we can also put our kids' assets in there. We have, young kids, but they have life insurance policies and stocks. So those can be, do we put them on their behalf? How does that work since it's
Absolutely, yeah. So your children are not the owner of their life insurance policies. So generally, you probably listed yourself as the owner. So you just have to contact the carrier and let them know that you want to change the owner of the life insurance policy to the trust. I recommend that you change the owner, the payer, and the beneficiary to the trust. Some people like to do a dual where they will have their children and the trust be co-beneficiaries of the policy. So it just depends on you.
okay, wonderful. Um, Additionally, for let's see here. Okay, I think with iPostal 1, it seems that you can only have one business name or entity tied to the address. Now you can have different representatives, but then one like people's name. It's like, for example, you're gonna have I already have an LLC, but then you have the three trusts that we are setting up. So is there any other virtual address places that perhaps you can list different entities? So, for example, what they're saying is that okay, in order for me to use the same address for these things, basically you got to get like three different accounts because they have three
Uh-huh.
different names.
Yeah, you can have one account, but you will have to have three different addresses under your one account. Um, but yeah, and then you can have multiple recipients, but they do have to be people's names. So, I don't really know of any other virtual companies, so you're just gonna have to do some research to see, but I have heard of other companies that they'll let you have multiple entities under one address.
Yeah, I found like two, but they're in different states. That's the only thing.
Yeah, I know. And that's why I don't recommend the smaller companies because their addresses are limited. And like I said, sometimes I see that they get rejected.
Yeah.
Rejected by the bank, rejected by, you know, other third parties.
Okay, no problem. Well, yeah, I just kind of wanted to put all three of them with the same address so we're not paying three different subscriptions.
Yep, I agree.
Okay. And then the ones with kids, bear with me one second here. That was already answered. Okay, I'll just pass it on here. I did have another one, but I can't see two kids about relatives. Okay, and filing taxes, of course, we're filing for each of these entities, minus the nonprofit if it's not making $5,000 in income.
That's correct.
Okay, yeah. So here's the last question. So before we learn about this and we're moving down this road, we had already had wills drawn up. So do we just do it with the will, or can the will be brought underneath or as a section somewhere in the write-up for the trust? Like, can we maybe include them as a paragraph, not a paragraph, but like a subsection or subcategory within there? Because they kind of explain other things that may not be in the trust as well. So is there a way to incorporate the will into the trust, or just it doesn't matter with the will anymore?
If you want to, the only thing that I would tell you is that if you have a will inside of a trust estate, it puts you at jeopardy for the entire estate, to go to potentially go through probate if the beneficiary decides to contest the will.
Okay.
But you can add it. So one thing is that everything that's inside of your will, you can add it into your trust. And then the will becomes obsolete. But if not, then you can add it within your trust documents. You can have another section, which is your last will and testament.
Okay, no problem. Well, yeah, I'll just incorporate some of the content then from the will into the trust. think that'll be better and do away with the will.
Yeah.
Alrighty. Thank you, ma'am. I appreciate it.
You're welcome, Chance. Thank you. Next we have Miss Leslie. How are you, Miss Leslie?
Hi, Christina. I'm
Hey,
good. Um, kind of the questions have been answered already, but it sounds like for a family trust that the grantor has more freedom, or do they just sign and notarize and then they're gone?
they sign, notarize, and then they're gone. So
Okay.
yeah, you just need them to apply for that EIN for you. And then and then you need their information for the banking institution. They'll ask for it.
And
But
information as their address and all that. What
name, address, and
Social Security?
social security number, correct.
Okay. And then yeah, I did not realize how in-depth this is.
Mhm.
I control the whole trust.
Yes, you do. Yep.
Okay.
So that's why we're here to empower you so that you get comfortable with these types of entities. You understand what's inside of the trust, so you feel empowered to know that you can operate a trust.
So how does this compare if an attorney draws up your either any trust or anything? Like, would they have liability if something goes wrong, or how does that work?
So there is a big difference between you doing it yourself and an attorney doing it. So with the attorney, they don't take any liability for your trust. What I've seen is some attorneys, they'll serve as your grantor for you if it's irrevocable. But generally, they will set up like a living trust for you. What I've seen is that what they do is that they'll have you set up the living trust, which is a revocable trust, which your assets are not protected. They'll list you as the grantor, the beneficiary, and the trustee. Um, and then with that type of trust, you're limited because they can only set up a trust in whatever state that, they are in and you are in, right? So it's a statutory trust that they're setting up for you because that's the way that they do it, right? So they put all the state statutes and codes in it, and you can only use it in that one state. So if you're, in Florida, you can only use that particular statutory trust in Florida. You can't use it anywhere else. But no, they don't take any liability, only if they're setting up an irrevocable trust and then they serve as your grantor, which I've seen that as well, but generally they don't.
Okay. Okay, that's all I have right now. Thank you.
Thank you, Leslie. Next, we have J.W. Lewis.
Hey there, can you hear me now?
Yeah, perfect. How are you?
Doing well yourself.
Wonderful.
Just a few quick questions. How many successor trustees can you have?
So I'm not sure if there is a limitation. I don't think so because you set the limitation. So generally people will do 1 to 2. If they're first, so they'll have like a first successor trustee and a secondary. So if the first is unable to or a non or unwilling, then they'll go to their second option.
Okay,
Yeah, but
and
I don't know if you can have like 10 or 15. I haven't seen it. I haven't seen it that extreme.
is a successor grantee ever needed?
No, so the trust is designed to outlive you, so the grantor is gonna die.
Okay.
And then when the grantor dies and these third parties ask you for grantor information, you will have to provide them with a death certificate, which is a part of the public records.
Okay, so the successor also includes if they pass, right? not if they're, just don't want to do it, or does that include that the successor trustee like listing them in the trust?
The successor trustee is only for the trustee, it's not for the grantor.
I understand. I guess you rephrased my question. I was trying to say if the the trustee passes and you have a successor, and the successor does not or is not willing, at the time to take on that that task, what kind of happens in that case?
Then at that case, you don't have a successor, you don't have a trustee and the beneficiaries, or so two things can happen. One, if you have a board of trustee, which is important, so you have a secretary as well as like a treasurer or a GTM, then those individuals can appoint a successor.
Okay. All right.
And then you'll be fine. And then whoever they appoint, they'll be able to take their position.
All right.
Now, if you don't have a board, then the beneficiaries are going to have to apply with the courts to get a court-appointed trustee.
Okay. Will that need to be in writing in the trust that this?
It's in the trust.
Okay. Last question. Oh, I remember yesterday you talked about maybe having responsibilities for the grantor and the trustee so they can see what they're getting into. Is that available somewhere?
Yeah, it is. It's you received it in your resources. So it's called the trust checklist. It's about maybe 5 or 6 pages.
Okay.
Um,
All right, that's good. And I guess the last question, I think you answered, the TCUs can be non-blood family members. And did you say it can go to their heirs if they want to?
Yeah, they have to record it that they want their TCUs to go to their heirs.
Okay. If a TCU receives a partial distribution like between 20 and 30 and possibly expire before that, does it go back to the trust?
Correct. Yeah. So if they don't have any heirs, then the TCUs go back to the trust. And then the trustee is going to
Okay.
redistribute the TCUs with the existing beneficiaries.
All right. Thank you very much. That's all the questions I have.
All right, thank you. And next we have Sheila.
Yes, thank you. Um, the protectors. We're not mandatory to have protectors, are we?
That's correct. It's optional.
Okay. Okay. And one example you gave was where I just want to clarify the scenario. You have the beneficiary and he says, well, I have my TCUs, but I want to uh, get the benefits of it. So I think we said, well, you give him his share and then you take the rest and divvy it up between the other beneficiaries.
Yeah,
Was
so that is when the trust is due to expire if they don't agree with the trust being
that's it.
renewed, then they can cash in their TCUs. That's an opportunity for them to cash in their TCUs. And once they cash them in, meaning they're gonna, turn in 30 TCUs, right? And so now they're going to receive whatever their portion is of the
Yes.
trust equivalent to the 30 TCUs. And then once those TCUs are cashed in, they are held in the trust, and then the trustee is going to redistribute those 30 TCUs to the remaining beneficiaries.
How do I avoid that? If I'm trying to build wealth and I'm thinking about many generations down the line, I might get a little greedy one that says, that's what I want to do. I don't want him to have the option of taking his units and doing what he wants to do with it. How do I avoid that? Because I'm thinking my whole idea is to build, but I might get a person, my son might say, hey, I want my share. But then that's decreasing the shares of his children.
So, what you can do is, you can remove it from your trust and then you can change the provisions to say that it's not allowed.
Great, that's what I want to do. What part of the trust can I or should I put that particular request?
Under the renewal part, so you have to, let's just go through it really quick. Where it says renewals,
Okay.
hold on. You see where it says renewals? So what
What
you're
Article 17?
correct, section
Okay,
2. Section 2, so you're going to change this whole section, and instead of you allowing that to be possible, now you're going to change the provision to restrict and not allow it to be possible.
great. Thank you.
All right, next we have Crystal.
Sorry, I'm back again. The wheel thing brought up something. My father has a wheel. He's 84 now. So I'm questioning what happens. You said that you can put the provisions that he got in his will into the trust. But not put the will in the trust, because that would cause an issue. Is that what I understood?
Correct, yeah, everything that's inside of the will, you're going to put it in the appropriate sections inside of the trust. So for example, if your father says, I want Crystal to have, the house, right? That's his wish, right? That's his last will and testament where he wants you to have the house, right? So with that, all you're gonna do is you're gonna put it inside of section D, where you are letting it be known that you want a specific asset to go to a specific beneficiary. So, whatever provisions, that he has inside of there, you can just, include them in the trust so that you can do away with the will.
Okay, so if the will is already publicized or recorded, I have to take that out, correct?
Yeah. Yeah, you just have to cancel it.
So cancel the will with the court office.
Mm-hmm.
Cancel the will, incorporate the information in the will in section D.
So it depends on what the provisions are. You want to put it in the appropriate section.
Okay. Now, one thing I didn't hear anything about is when an elderly person has to go to a skilled nursing facility. Are there any provisions that need to be put into the trust for when that happens? Or it just protects, the property is protected from going to the skilled nursing facility? Is that what happens? Am I making sense?
So it depends on what you're specifically talking about. So are you talking about if they like abandon their residence, or are you talking about like directions for their medical needs?
Well, what happens normally if whatever is in a person's name and they're not able to pay for permanent resident at the skilled nursing facility, they take the assets.
Mm-hmm. Yeah, Medicare, ACA, those agencies, they do that.
Right. So my question is, are there any provisions that from the trust that protect when you put the property in the trust? Are there any provisions, any additional provisions that are required to protect the property from being given to the skilled nursing facility?
So if the property is not in their personal name, then it's already protected. It's in a
Okay,
trust.
gotcha.
It's in a trust, yeah. I think it clicked. So it's in a trust, and it doesn't belong to that elderly. Because yeah, they will do that. They will file like a list pendant on your property, and they'll make claims against it. I've seen it already. I've already seen it, and they make sure that they get their half, right? Whatever's owed to them. Um, during the probate process. So that's why you are already fully protected if that property is in a trust and not in that person's name.
Okay, so I have to go and actually change the property that's in my parents' name. I have to change that and put it in a trust as soon as
Yeah.
possible.
Yeah, or it's gonna go to probate, or, any creditors, the government, ACA, Medicare, Medicaid, all these agencies will
And
go
that's
after.
including the timeshare too, correct? The timeshare that they have.
Yeah, you have to contact the timeshare company.
Okay, thank you.
You're welcome. All right, next we have Nia. Hey, Nia, how are you?
I'm well, thank you. How are you?
Oh, good. Nice to see you.
Nice to see you as well. Okay, so there was one question that I missed yesterday, but it's all relevant to now. If so, I had one day I got something notarized, and the young lady who was notarizing that document said that she couldn't notarize trusts. Are there notaries that can't notarize trusts?
It was that at a bank?
No, she was just a person like that does notarizations.
To my knowledge, it depends on like if they're employed by a certain like institution or something like that. I've seen that where notaries are restricted, and they can only notarize certain documents, but that's because of their employer. So I don't know if that was her situation, but generally most notary publics can notarize all documents that need to be notarized.
Got it. Thank you. And okay, so my other questions. So I feel like I have a million trusts and I never understood any of them. So I'm finally understanding now. When I had a trust created prior, they didn't tell me that I was supposed to take the certificate of trust, let's say to the bank or to any place else, to utilize that as the trust document and hold on to the other pieces for my own private, documentation. With that, I see that there's several different documents here on this family trust that needs to be notarized. What specific parts of this do I take to, let's say, the bank, etc.?
The certificate of trust. So one of them is the declaration being notarized. The other one is the indenture being notarized. The other one is the Schedule A being notarized. The other one is the distribution of TCUs being notarized. So those are 4 pages. And then the last page that's being notarized is a certificate of trust. So that is the only one that you have to bring with you to most places to prove that the trust exists. So you bring it with you to the county, to, the bank, to, any place where you're either acquiring or liquidating assets or doing transactions. You can, give it to the brokerage, you can give it to the insurance company. So a lot of places will specifically ask you for it. A lot of other financial institutions will ask you to fill out their own certificate of trust.
Okay. And you said most places. So with the other places that don't just accept the certificate of trust, are there other pieces of this that need to be produced or just yeah.
So some places will actually ask for the notarized indenture. So that would just be like the first page after the first notarized page after the actual trust agreement. They'll ask for that.
Okay, perfect. Thank you. Now, I have another family trust, or yeah, I have another family trust or other trusts that are not funded. Could I, let's say, just obviously because it's not funded, it hasn't been like, given to anyone, create my own trust for those old trusts, or would that be like some type of fraud? Like, since I'm doing these trusts, like learning how to do this now, could I just like produce a different trust for those EINs?
So those trusts they've already been notarized and you got EINs.
I have any EINs, yes.
They didn't get notarized? Because if they didn't get notarized, then they don't exist.
Got it. One did get notarized, one didn't.
Okay. If you don't plan on using a notarized trust, then you have to terminate the trust. You
Got
have
it.
to have a board meeting and terminate the trust. And then you could create a new trust. And if you wanted to use the same name, that would be okay. As long as you don't have, two entities with the same name. So you would have to terminate the old one.
Okay. How do you terminate that? Just like go in and like close out the EIN?
So you can contact the IRS and let them know that you're not going to use the EIN. But the way that you terminate a trust is you have a meeting for the trust saying that you're going to terminate the trust.
Got it. And then note that. Okay, got it. Okay. So you mentioned something when you were speaking to someone else about using a statutory trust in that state only, but since this is a non-statutory trust, you can use it in any other state. This might be a question that I'm not sure, like it may be like obvious, but when you say use it in other states, do you mean like take assets that are, let's say, in multiple states and put it in that trust that you have now? That's a non-statutory trust.
Correct. Yeah, that means that you can use it in all 50 states, all US territories. So for example, if you set up a trust today and let's just say you're in Texas, right? So now the domicile of this trust that you set up, that's a non-statutory trust, the domicile is in Texas, right? So you can use it all up and down Texas, right? But let's just say that you have a rental property in California. If you have a statutory trust, you cannot use that Texas trust in California. But because you have a non-statutory trust, you can use that Texas trust, you can use that non-statutory trust that has a domicile in Texas, you can use it in California. So let's just say you have a rental property in California and you want to put that rental property into your non-statutory trust, you can. So now you're utilizing this trust in Texas and in California, and you can continue and rinse and repeat. You can use it in Arizona, Nevada, Florida, Georgia, wherever.
Got it. And my last question. So what is your advice on actually having the trust in the Virgin Islands? US Virgin Islands, not British. I have multiple properties in my family in the Virgin Islands, and do you like how would I like put that as like the state and the county, and do you advise to even do it in the Virgin?
I mean, yeah, the Virgin Islands is good. It's still a US territory and it's still domestic, and your trust you can utilize them over there. And especially if you have multiple assets over there, then you definitely want to. You don't necessarily have to create the domestic trust in the Virgin Islands, but you can still use it there. So back to the example. If you set up the non-statutory trust in Texas, you can still use it in the US Virgin Islands. You can use it in Guam, Puerto Rico, Hawaii, all these different places.
All right. Thank you so much.
You're so welcome. Thank you, Nia. Next we have Kamala.
Hi, sorry again.
No problem.
Yeah, it goes back to the same question that she was asking because I have property in my family have property in Jamaica and I have property in Panama. Can you put those property in the trust?
No, these are domestic trusts, so they only go for US and US territories. So
Ah, so
you have to put those international, you have to put those properties into an international trust.
so it
So,
has to be a separate trust?
correct.
Oh, so I have to create a separate trust for that. Wow. All right. I'm sorry. Thank you. Next question. I live in New York, and with trust, it's a whole different ballgame in New York. It's like it's not the same as in the other states.
Mhm.
It's just, yeah, the laws are so rigid. So with the list you sent to me, with people you could reach out to, is there anyone on there that's from New York?
Oh, we have like majority of the people are in New York. So there's a lot of people in New York, a lot of people.
Okay, good. So I just need to just go through the list and hope I find somebody that's from New York because I want to reach out to somebody that's from New York.
Okay, so I will try to put you in contact with the people that's coming to my head right now.
Okay, all right, wonderful. So you have my email and
Absolutely.
phone number. Okay, so that would be great if I get that information.
Okay, sounds good.
All right, thank you. Thank you so much.
You are so welcome. All right, next we have Miss Leslie. And then we have Miss Joyce, and then we're gonna be done for today, you guys.
Hi.
Hi.
So, can you use the same grantor for all your trust?
Yes, absolutely.
And what if you need to add to the trust, like babies coming into the family? Is that difficult?
No, it's not. So, all you have to do is if you're gonna list them as a beneficiary, you'll just have a board meeting, appointing, new beneficiaries to your trust.
And then you mentioned for the length of the trust, um, is it better to put more years so you don't have to change it, or is that easily changed or no?
Yeah. Yeah, so it's better for you to list the maximum of time possible. And then if you, for example, if you put your term as 100 years, but let's just say at the 50-year mark, you're like, I'm done, I want to terminate the trust, you can do that. So you know that would be the best option if you wanted to do the least amount of renewals as possible.
Okay. Okay, thank you.
You're welcome. All right, next we have Miss Joyce, and then we are going to wrap up day 2 of the Wealthy Trustee Workshop.
Okay, hey. Um, the lady, okay, I have a EIN number for a business that has gone to bunk many years ago, not using it anymore. Can I use that EIN number to be the EIN number for my trust?
No, so an EIN number for a sole proprietor, for a corporation, for an LLC, or for a trust or an estate are different. So when you applied for that EIN number, that was only for that specific entity, and then that specific entity is not a trust.
Okay. Second question. The questions that are being asked in the chat, do you answer those as a part of the recording that you can go back to?
So that is a good question. So I'll be able to review it after. But the only issue is that I'm not able to, know exactly because of the screen name. So I don't, if you have a different screen name, then I'm not able to send you the response.
Oh, it wasn't even my question. It was just a question that was in the chat that I found interesting. And It literally, it was from Jay Taylor. When you say research the state, you want to open your trust in, is there a criteria we should be looking for from that particular state?
Yeah, so I'm gonna answer this question the way that I've been answering it, which is those every single state has their own laws when it deals with trust. Those those types of trusts are statutory trusts, and that state, those statutes and codes are embedded in that trust. So,
Gotcha.
so a lot of people, they still like to choose a state that has favorable statutes and codes, even though they're not setting up a statutory trust. So you have to decide if that's what you want to do.
Okay. All right. Well, Bay, was that the question? Okay. He said I asked his question. So you all have an amazing day and see you tomorrow.
Thank you, thank you, thank you. All right, hold on one second. All right, awesome. Hold on one second, you guys. I'm trying to pull up this. Okay. All right, guys. So we are going to wrap it up for today. So I'm super excited that we are almost halfway done. So the homework that I have for you guys for today is yesterday, you should have gotten into the Facebook group, the Telegram chat, and introduce yourself. So today, what I want you guys to do is go ahead and let us know why you decided to become a wealthy trustee and protect your assets. So just let us know so that we are able to hold you accountable for that. And then also start working on the asset inventory list. So you did get that in your email yesterday and in your welcome email. So it is a worksheet for you guys to prepare for Friday. So on Friday, what we're doing is we are going to be focused on transferring assets. And so you want to start working on that inventory list now so that you know what assets that you have and which assets are going to go inside of the trust and which assets are going to stay outside of the trust, because not all of your assets qualify to be owned by the trust. So you actually working on that asset inventory list will be able to help you. Some people have found it so helpful that they didn't even know that they had old retirement accounts and 401ks and different financial accounts that they totally forgot all about. So that's going to be a worksheet that you can then also add it to your trust records just in case anything happens. You have all that information in one central location. So with that being said, we are going to meet here tomorrow on Zoom at 11 a.m. Eastern Standard Time. Tomorrow, we're going to be working on the nonprofit tax-exempt trust, which is also known as our 508c1a ministry trust. Tomorrow, we are also going to apply for the EIN for that trust. So if you're able to finalize who your grantor is and get their personal information, then you'll be able to do it step by step alongside me when we go through that whole process of setting up the EIN. So with that being said, tomorrow you're going to receive an email 1 hour before the workshop with the resources and templates that you're going to need for tomorrow, as well as the Zoom link. So I hope everyone has a beautiful, amazing, and blessed day, and I'll see you tomorrow here on Zoom. Bye-bye, everybody.
Thank you.
You're welcome.
Thank you.
A peace and blessings.
Bye.
Bountiful blessings.